The Honourable the President.
Let us pray. Almighty God, we willingly acknowledge you as a supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Announcements by the President. Bills brought from the House of Representatives. On the supplemental order paper, the Planning and Facilitation of Development Amendment Bill 2018, in the name of the Minister of Planning and Development. Petitions, papers.
Vice President.
Thank you, Madam President. Madam President, I have the honor to lay on the table the following papers as listed on the order paper and supplemental order paper in my name. The sessional report of the third session, 2017-2018, 11th Parliament of the Republic of Trinidad and Tobago. The annual report of the Judicial and Legal Service Commission for the year 2017.
Transport.
Madam President, I have the honor to lay on the table the following papers as listed on the supplementary order paper in my name. The ministerial response to the Ministry of Works and Transport to the fourth report of the Joint Select Committee on Land Physical Infrastructure, third session, 2017-2018, 11th Parliament, on an inquiry into the Trinidad and Tobago inter-island ferry service with specific focus on procurement and maintenance of ferries. I thank you.
Government business.
Thank you very much, Madam President. Madam President, I have the honor to lay on the table the following papers as listed on the order paper and supplemental order paper in the names of the Minister of Social Development and Family Services and the Attorney General. The ministerial response of the Ministry of Social Development and Family Services to the 8th report of the Joint Select Committee on Human Rights, Equality and Diversity, third session, 2017-2018, 11th Parliament, on an examination of the perceived inequality faced by single fathers in Trinidad and Tobago, with specific focus on custody matters, policies, and access to programs and services. The Criminal Procedure Amendment No. 2 Rules 2018 and the Civil Proceeding Amendment Rules 2018.
Reports from committees.
Senator Mark.
Thank you, Madam President. Madam President, I have the honor to present the following reports as listed on the order paper in my name. The 14th report of the Public Accounts Enterprises Committee, third session, 2017-2018, 11th Parliament, on the examination of the audited accounts, balance sheets, and other financial statements of the National Commission for Self-Help Limited, NCSHL, for the financial years 2008 to 2015, and the 15th report of the Public Accounts Enterprises Committee, third session, 2017-2018, 11th Parliament, on the examination of the audited accounts, balance sheets, and other financial statements of the Youth Training and Employment Partnership Program, YTEPT, for the financial years 2008 to 2014.
Minister of Labour and Small Enterprise Development.
Thank you kindly, Madam President. I have the honor to present the following report as listed on the order paper in my name. The 11th report of the Joint Select Committee on Local Authorities, Service Commissions, and Statutory Authorities, including the THA, 4th session 2018-2019, 11th Parliament, on an inquiry into the efficiency and effectiveness of the Regulatory Industries Commission. Thank you, Madam President.
Urgent questions.
Senator Mark.
Thank you, Madam President. To the Honorable Minister of Works and Transport, in light of reports that someone impersonating a G4 security officer walked away with a large sum of money from a Caribbean Airlines counter at Piaco International Airport, does this pose significant implications for the international rating of said airport?
Madam President, category, no. The incident refers to does not and is not related to the rating and status of the airport. The status of the airport relates to the standard and practice which are being measured by the International Civil Aviation Organization, which, Madam President, are unrelated to the issue of purported robberies. Thank you.
Madam President, can I, through you, ask the Honourable Minister if you can share with the Senate what was the large sum of money that was removed? What was the size? What was the sum involved or the value? Could you share that with the Honourable House?
Senator Mark, that question. Next, supplemental.
Can I ask the Honourable Minister then, Madam President, what are some of the standards and practices that will determine, for instance, our ratings, either upward or downwards, in the instance of re-rating of our international airport, as you have outlined?
Senator Mark, that too does not really arise. Next question.
To the Minister of Works and Transport, in light of reports that a large sum of money was stolen from a Caribbean Airlines counter at Piaco International Airport, what is being done to immediately address security issues both in and around the airport?
Minister of Works and Transport.
Thank you, Madam President. Madam President, the Airport Authority continues to work with all its tenants and concessionaires to ensure the systems are enforced in accordance with international airport standards. In addition to the security systems operating at the Airport Authority collaborated in collaboration with the TTPS to enhance security arrangements in and around the terminal building. Thank you.
Senator Mark.
Madam President, can the Honourable Minister indicate to this Senate what is the system or what systems are employed by the Airports Authority to ensure that standards are maintained?
Minister.
Thank you. Madam President, this incident yesterday is an incident with a breach at a CAL counter and not necessarily a breach by the Airport Authority. And as I said, the Airport Authority continues to work with its tenants and concessionaires to ensure that the systems are enforced in accordance with international airport standard with their internal security. I thank you.
Mark.
Madam President, can I ask through you to the Honourable Minister, what was the sum? We hear about a large sum of money and all kinds of speculations are being raised here and there. Can the Honourable Minister share with this House what is the value of the sum involved? Can you share that information with this Honourable House?
Minister.
Madam President, again, the money that was removed from the CAL counter is not the airport authorities' funding, and as Minister with responsibility for the airport, I am not in a position to comment on the amount of money that CAL would have lost. We have, the airport authority have asked CAL for a detailed report on the incident, and until then I cannot comment on the money that CAL would have lost.
To the Honourable Minister of Public Utilities, given the recent issues at the Point Lisa's desalination plant, which continue to affect the pipe-borne water supply to a large number of citizens, can the Minister advise when will said water supply be resumed?
Minister of Public Utilities.
Madam Speaker, you would recall that on Tuesday the 4th, the last sitting of the Senate, I explained to members of the Senate that the water supply to the population from the desalination plant was disrupted on the 3rd of December as a result of an electrical defect on the plant due to salt water corrosion. The original information coming to me and that I relayed to this House was that the production of water back to the citizens would have happened on a phased basis, the increased production, and by Wednesday, the next day, that they would have gotten back up to full production of water. Subsequently, as a result of additional problems at the plant, the company was only able to take its production up to 30 million gallons by Sunday. And as a matter of fact, on that day, there was actually another problem which resulted in the plant dropping the production to 5 million gallons, but within a short space of time, they were able to ramp back up to 30 million gallons. There were additional needs for additional parts to be flown in, and these parts are arriving tonight from Finland via air freight. As a result of these changes and these events, the plant is now producing, as I said, 30 million gallons of water. It's expected to go up to 36 million gallons as they work overnight and they fix the particular problems. But full production, back up to 40 million gallons, is not expected until Friday of this week. Again, I do apologize for the hardship, and WASA continues to try to alleviate this problem.
Senator Mark.
Thank you, Madam President. Madam President, can the Honourable Minister, through you, share with this Honourable House what were some of the additional problems encountered by this plant? Could he share with us what were those additional problems?
Minister.
Thank you, Senator. Thank you, Madam President. Basically, there was an electrical problem that, as I said, it was a result of corrosion. The problem was actually fixed using the spare parts that were available. However, that particular spare part, again, another electrical problem when they were about to start the plant up. There was a surge of electricity again, and there were certain problems that arose, which then caused a burnout of another particular equipment, another part, which, as I said, needed to be flown in from Finland. So they are all electrical related, but as one was fixed, another one happened, and therefore the parts needed, this particular part needed to be flown in from Finland, and it's going to be arriving tonight.
Senator Mark.
Given the effective nature of this desal plant, can the Minister indicate to this House what steps are being taken to ensure that problems that he has identified will not arise and thereby affect the population in South and Central Trinidad? Can you identify and can you give this House the assurance?
I won't allow that question.
Questions on notice. Questions for oral answer.
Leader of Government Business.
Thank you, Madam President. Madam President, the government seeks a deferral of questions 13, 14, and 15 for 2 weeks, and we will be answering all other questions on the order paper.
13, 14, and 15 are deferred for 2 weeks. Senator Mark.
Question number 29 to the Minister of Energy and Energy Industries.
Minister of Energy and Energy Industries.
Thank you very much, Madam President. Madam President, McKinsey did not produce any report per se. McKinsey was engaged as industry experts to help the board to understand and design solutions to the continuously deteriorating operations of Petrotrin. This was done in incremental work streams that involved experienced Petrotrin subject matter employees working in a team together with the consultants. At any one time, McKinsey had between 8 to 10 experts working along Petrotrin staff for approximately 1 year. The global cost was US $9.9 million, paid as at October 28, 2018, covering the following work modules: initial engagement, strategic review A; B, review of upstream operations; C, review of downstream operations; D, organizational design; and E, transition phase, which is still currently in progress. With regard to Solomon and Associates, the cost of consultancy was $1,279,000 US and covered the following activities. First invoice, $164,850. Petrotrin Workforce Optimization Study, Phase 1. Invoice number 2, $384,650 US. Petrotrin Workforce Optimization Study complete. Invoice number 3, $90,000 US. ENP benchmarking exercise, 50% professional services. Invoice number 4, $549,500 US. Professional services, 100% contract awarded. And $90,000 US. Invoice number 5, ENP benchmarking exercise number 2, giving a total of $1,279,000 US.
Senator Mark.
Madam President, can the Minister indicate to this House what exactly did McKinsey submit to Petrotrin and by extension the government and people of the Republic of TNT for close to 60 million TTWs?
Senator Mark, I believe that that was covered in the minister's response, so perhaps you can ask another question.
Can I ask the Honourable Minister through you if he can give us a breakdown, Madam President, of this 9.9 or roughly 10 million US dollars that was paid to this firm, exactly what areas he can provide to us that money went towards?
Minister.
Well, if the question is so worded, I will be compliant to answer. So if you can phrase the question to say each invoice, what it was for, I will comply.
Senator Mark.
Can the Honourable Minister indicate whether, based on the reports of the body, the McKinsey report as it is called, or submissions, whatever it is called, Madam President, can the Honourable Minister indicate to us whether in their submission any recommendations would have been made for the shutting down of Petrotrin, particularly the refinery operations? Can you share with us, Honourable House, whether any of their submissions surrounded that particular proposal?
Minister.
Madam President, as we have said on numerous occasions, there wasn't one specific report from any party or parties that said take the action which we did, which is the shutting down of the refinery and remodeling the operations of former Petrotrain in the way we have done. It was the cumulative effect of a series of studies and intervention that finally distilled the decision, and the decision was made in the interest of the people of Trinidad and Tobago, the interest of the energy sector of Trinidad and Tobago, and in particular the interest of the oil sector in Southwest Peninsula.
Senator Mark.
Based on the fact, Madam President, that we have spent close to 70 million TT dollars on this McKinsey group, can the Honourable Minister indicate to us what is tangibly available for the public so we can actually see and feel as it relates to that sum of money that was expended by the taxpayers to this particular organization called McKinsey? Can we see anything concretely? Can you make anything available to this Honourable House?
Senator Mark, I won't allow that question. Next question, Senator Mark.
Question number 30 to the Minister of Agriculture, Land and Fisheries.
Minister of Agriculture, Land and Fisheries.
Thank you very much, Madam President. I thank Senator Mark for his question. Madam President, the Ministry of Agriculture, Land and Fisheries has a section of state land at Royal Engineer Road, Ari Road, Losiro, designated for food crop farming. The Losiro food crop project comprises approximately 270 hectares with 149 plots divided into 3 phases. The August 2nd earthquake damaged a section of Phase 1. Madam President, the damage caused by the earthquake included deep land settlement, which caused major disruption of certain sections of the roadway, actual movement of entire sections of the road off its original alignment, damage to farm ponds, substantial movement of cultivated lands and farm plots, land movement affecting shed and yards, and land movement along the coastline. 9 farmers were affected. These farmers are Keshwar Basdev, Balchan Singh, Danraj Saga, Ishwar Dwarka, Kumar Dwarka, Premati Samaru, Sunil Bal Singh, Lady Pierre, and Selvin Karim. On investigation, Madam President, it was found that one affected farmer was in illegal occupation of a substantial part of the forest reserve. This will not be allowed to continue on that site because it will continue to degrade the stability of that particular area. The Engineering Division of the Ministry of Agriculture, Land and Fisheries conducted several assessments and identified work to be done for site rehabilitation. Madam President, I'm pleased to advise that the entire project is now accessible by vehicles. Relocation of affected farmers to locations in close proximity remains an option, but is conditional upon the farmers ceasing all cultivation activity on the affected plots. I thank you.
Senator Mark.
Madam President, can the Minister indicate to us, to the Senate, whether the farmers who have been affected, including the illegal farmer, can you indicate whether they are back in active agricultural production since the efforts have been made to rehabilitate those areas affected by the earthquake?
Minister.
Thank you very much, Madam President. I'm happy to say that the ministry was able to assist with the preparation of those affected plots, and to date the farmers have, initially they went in and they were able to reap some of the produce, and they are back to cultivating their lands, and the issue of the long-term occupation and use of it is something that is still outstanding.
Senator Mark.
Madam President, can the Honourable Minister indicate what compensation, if any, would have been offered or paid to these farmers during the period of dislocation and distress?
Minister.
Madam President, there is no policy of the government which caters for compensation to farmers for losses arising out of natural disasters and related matters. But, Madam President, I must also say that there is some assistance that is available to farmers affected in this manner. But as of Friday last, the ministry received no application or request for assistance. Thank you.
Senator Mark.
Madam President, can the Minister outline what assistance is now available to farmers which they are yet to access?
Minister.
Madam President, the assistance available to the farmers that assistance has already been rendered. It consisted of repairs to the roadway, immediate repairs, assistance in preparing the land that was affected so that they could return to the land, and that is the assistance that they have asked for, and that is the assistance that has been rendered.
Senator Mark.
Can I ask the Honourable Minister what crops these farmers are able to engage in and provide to the market in this country? What particular crops they are engaging or specializing in?
No, Senator Mark, I won't allow that question. Next question, Senator Mark.
Question number 31 to the Honourable Minister of Education.
Minister of Education.
Thank you very much, Madam President. The University of the West Indies and the Western Campus has advised that given the delays caused by contractual matters and unpredictable weather, the campus management thought it prudent not to advertise programs to be offered at the DB campus in 2018-2019. No student has been affected, as there were no new or continuing students registered to read courses or programs at the DB campus in the academic year 2018-2019. In light of the above, no mitigation measures targeted at prospective students are needed at this time. With respect to the completion date of the facility, the campus management advises that work towards completion and handover of the DB campus continues apace as follows. A, the internal works on all buildings are almost completed and furniture installations have commenced in several locations. B, the installation of the information, communication, and the technology components, ICT, has also commenced. C, final arrangements are being made for multimedia and audiovisual installations to commence. D, the services infrastructures are also nearing completion, and initial testing and the commissioning have commenced on the water storage and the distribution systems and on the wastewater treatment plant system. And E, December 31st, 2018, is the deadline date for handover of all buildings, with the commissioning of the ICT and the multimedia and the audiovisual systems earmarked for completion by February 2019. Thank you.
Senator Mark.
Minister, did I hear you say that by February of 2019, you anticipate, based on the advice that you have received, that the campus would be up and running? Did I hear that, sir?
Minister.
Madam President, for Senator Mark's information, I said that all the systems are earmarked for completion by February 2019. That's the answer.
Yeah, Madam President, through you, can I ask the Honourable Minister, when in his estimation, based on the reports that you have before you, you anticipate the operationalization of the campus and the use thereof by students? Can you share with us your information in this regard?
Minister.
Madam President, although this is a matter solely in the hands of the University of the West Indies, the information that is available to me is that every effort is being made to have this campus off and running in the academic year 2019-2020. Thank you.
Senator Ramdeen.
Thank you, Madam President. I want to thank the Minister for the information that we've been provided with this afternoon, Madam President. But, Madam President, I want to ask the Minister, when last did the Minister go down to DB and visit the campus to see the work that is being done and to assure himself that these completion dates that have been given to us will be met by the contractors who are involved in the work down at DB?
Senator Ramdeen, that question does not arise. Next question, Senator Obika.
Thank you very much, Madam President. Question number 56 to the Minister of Energy and Energy Industries.
Minister of Energy and Energy Industries.
Thank you, Madam President. Madam President, I think I will start by saying I have to give Senator Obika a crash course in energy terminology. He asked how many days a week supply of fuel will be stored in the designated bunker. This is not an army bunker. Bunker is not storage in the energy sense, but a type of fuel used by ships, which includes fuel oil and gas oil. Bunkering is the sale of bunker to passing ocean-going vessels. Let me repeat that for you?
Yes, I think so.
Bunkering is the sale of bunker. Bunker is not a storage to passing ocean-going vessels. The bunkering operation will continue at Pointe-à-Pierre to vessels in the Gulf of Paria. Inventory is based on the demand for fuel and is typically a month's supply, which is approximately, based on the market, 100,000 barrels. The cost of bunkers will be driven by international prices because we are no longer producing bunker from the refinery, we are purchasing it, structured in a manner to ensure the sustained profitability of the bunkering operation. For Paria to survive, it will purchase bunker on the international market, have a markup, and we sell it to passing ships, and that is the business of trading. I so direct, Madam President.
Educate. Senator Obika.
Thank you very much, Madam President. Unfortunately, the Honourable Minister has not indicated a single item of cost. So I wish to ask the question, what is the cost of saving, not international prices? There must have been monies expended by the state. Can the Minister inform the Senate? What is the cost?
Minister.
Madam President, Senator Obika continues to baffle me. He's an economist. Paria is involved in a business of purchasing bunker, having a markup, and reselling it on the international market in a competitive environment. So I must come here and tell you, every single price that Paria purchases bunker at, and every single sale they make to every ongoing ship, it will destroy their competitive advantage. Okay? So let's get real, Madam President. This is not politics. This is business, and Petrochina has been restructured to operate as a business venture. So let's respect that.
Senator Obika.
Thank you very much, Madam President. The Honourable Minister in his submission stated that there will be 1 month storage. Could the Honourable Minister indicate, you giving a range, what is this 1 month storage expected to cost the citizens of Trinidad and Tobago, or admit he was unprepared to answer the question today?
Senator Obika, I won't allow that question. Next question, Senator Obika.
Do I have another supplemental to this very question that I can ask?
Yes, you do, Senator Obika.
Right, so could the Honourable Minister indicate what is the average cost of the inventory that he indicated should be at least 1 month's supply?
I won't allow that question, Senator Obika, based on the answers that have already been given. You have one more supplemental question to ask. Next question, Senator Obika.
Thank you very much, Madam President. Question number 57 to the Minister of Energy and Energy Industries.
Minister of Energy and Energy Industries.
Thank you very much, Madam President. Madam President, both super gasoline and diesel fuel generated subsidies, whereas premium gasoline generated a small surplus, as is commonly known. The subsidy on super gasoline and diesel fuel for the period 2016 to 2018 is as follows. In 2016, the subsidy on super was 83.4 million. The subsidy on diesel was 438.1 million. In 2017, the subsidy on super was 253.3 million. The subsidy on diesel was 450.9 million. In 2018, the subsidy on super was 500.23 million. The subsidy on diesel was 412.9 million. The subsidy per liter generated on the super gasoline and diesel fuel over the period are as follows. In 2016, the subsidy on super was 12 cents per litre, TT cents. The subsidy on diesel was 88 TT cents per litre. In 2017, it was 38 cents for super and 99 cents for diesel. In 2018, it was 76 cents on super and 96 cents on diesel.
Senator Vieira.
Thank you very much, Madam President. I'm very grateful for the submissions made by the Honourable Minister. And I wish to ask why premium was not added, if not to say that there was no subsidy on premium.
Minister.
I didn't, you lost me there. Just repeat it, please, and I'll answer it. Yeah.
Just for the record, for the public's interest, there was no mention of any subsidy applied to premium, and I wish to ask the minister if that was because there was no subsidy applied to premium gas.
The answer is that the price of premium approximates the international market price, and sometimes it actually generates a small surplus for the state.
Senator Vieira.
And the other supplemental I wish to ask through Madam President is if the Honourable Minister has any indication as to a timeline as to when the subsidies on diesel and super may be or would be removed.
Minister.
At the last budget, the 2017 budget, the Minister of Finance did indicate that is the intention of the government to phase out the subsidy of fuels. While it is still our intention to so do, there are consequences to that, and we are very cognizant of that, especially as we have to go ultimately to a market-driven price, where prices is posted, say like in Jamaica, every month, where the prices change. In the United States, it virtually changes every day at the service station. With fluctuating oil prices, that is a cumbersome system to manage, and it can cause great aggravation to the population, where you get up every month expecting to see a price increase in the price of fuel. Conversely, there can also be a decrease in price. So it's a difficult situation we are in. We have removed most of the subsidy based on the $55 oil price that we forecasted in 2017. However, with the $65 forecast for this year, this fiscal year, the subsidies would have gone back up. And we are monitoring the situation very, very closely.
Next question, Senator Obika.
Thank you very much, Madam President. Question number 58 to the Minister of Education.
Minister of Education.
Thank you very much, Madam President. The University of the West Indies, UWI, does not have a policy on incomplete course curriculum arising from class disruptions caused by natural disasters. However, in the wake of the recent widespread flooding that occurred during October 2018 and which affected many of the staff and students, the campus management directed that measures be immediately implemented to facilitate the students and minimize the impact of those unforeseen events on their studies. Accordingly, the following measures were put in place. 1, examinations were rescheduled. 2, deadlines were extended for the submission of assignments. 3, makeup classes were conducted as soon as affected students were able to resume. Additionally, students who indicated that they were severely traumatized by the flooding were offered counseling services to manage the flooding trauma. Leave of absence for semester 1 in the first instance, and the option to read fewer courses depending on their ability to cope. Thank you.
Senator Obika.
Thank you very much, Madam President. In light of the Honourable Minister's submission that some persons may have taken leave of absence, is there any provision that the university has communicated to him to allow them to recoup, to do over these courses in the summer or in the short semester, sorry?
Minister.
Madam President, my response is clear. if the university management has decided that they'll allow students to defer courses, obviously they will take into consideration allowing them to write those courses later on. Simple as that. Thank you.
Senator Obika.
Madam President, from my understanding, the summer program, the vacation, the short semester program is hamstrung to some extent at the university. So I want to ask the minister if, particularly, if they will be accommodated in this academic year in the short semester.
Well, I think the minister, you've just repeated the question.
At a later date.
But you've repeated the question, so you can ask another supplemental.
Oh, no, I don't wish to.
Yeah? Okay.
Requests for leave to move the adjournment of the Senate on definite matters of urgent public importance.
Senator Mark.
Yes, ma'am. Just looking for my document. Thank you. Thank you very much, Madam President. Madam President, in accordance with Standing Order 16, I hereby seek leave to move the adjournment of the Senate for the purpose of discussing a definite matter of urgent public importance, namely the lack of accountability and transparency in the sale of Petrotrin's assets. The matter is definite because it pertains specifically to the government's intention to sell the assets of Petrotrin without proper public procurement, transparency, and accountability. The matter is urgent because the government has now indicated that within 30 days, they intend to secure a new owner for Petrotrin's assets. As such, the procurement regulator is unable to oversee this transaction to ensure that there is accountability and transparency in the disposal of said assets. The matter is of public importance because Petrotrin, as a state enterprise, was owned by the state on behalf of the citizens of Trinidad and Tobago. Any disposal of its assets must be subjected to the full requirements of the public procurement laws. I so too.
Honorable Senators, I have considered the motion, and I am not satisfied that this matter qualifies under this standing order.
Personal explanations.
Minister of Works and Transport.
Thank you, Madam President, and thank you for the opportunity to correct the records. I refer to a response to question number 54 in the Senate of the Republic of Trinidad and Tobago on December 4, 2018, and wish to advise the following. Based on the information received from the Trinidad and Tobago Civil Aviation Authority, at the time when the question was posed, there were no applications from Sunwing Airline Incorporated to operate direct flights between Toronto and Tobago, Toronto, Tobago. However, on return to office on instant day, information was received that an application was subsequently lodged. This application is currently being evaluated at this time. Thank you, Madam President.
I wish to ask if I can seek clarification, given that was the question I raised.
No, Senator Obika, under the standing orders, you are not allowed to so do.
Public business, government business, bills second reading.
Attorney General.
Thank you, Madam President. Madam President, I beg to move that an act to amend the Magistrates Protection Act, Chapter 603, be now read a second time. Madam President, I'm sorry to ask you this, but how much time is there permitted in this House
45 minutes.
45 minutes, much obliged. Madam President, it gives me great pleasure today to pilot what on the face of it seems to be a short and rather simple piece of law. It isn't quite that, however, when one appreciates the depth that this law cuts through. Madam President, the bill before us seeks to form a leveling of equality to allow magistrates a certain privilege, a certain status, a certain immunity that is afforded to other parts of our judicial system. This bill, to be understood in its correct form, requires a little bit of an historical journey. It requires an appreciation as to where our society has come to at present. It requires an understanding of the administration of law as it is now in Trinidad and Tobago to be applied, and an appreciation of what is to come ahead of us. So permit me, Madam President, by starting off with the supreme law of the Republic of Trinidad and Tobago, which is the Constitution. And I wish to start by way of reflection upon the preamble to our Constitution, which, of course, by way of expression in 1976, confirmed that the people of Trinidad and Tobago have affirmed that the nation of Trinidad and Tobago is founded on principles that acknowledge the supremacy of God, faith in fundamental human rights and freedoms, which I stress, the position of the family and society of free men and free institutions, the dignity of the human person, and equal and inalienable rights with which all members of the human family are endowed by their Creator. That's in subparagraph A. Similarly, in subparagraph C, the people of Trinidad and Tobago in our written constitution have asserted their belief in a democratic society in which all persons may, to the extent of their capacity, play some part in the institution of national life, and thus develop and maintain due respect for lawfully constituted authority. I turn next, Madam President, to Section 5 of the Constitution, in particular Section 5F, subclause 2. And that, of course, is in reference to protection of rights and freedoms and the manner in which we deal with the derogation of those rights in Section 4. But in subsection 5(2)(f), Roman 2, we say that except as otherwise provided in this chapter and in section 54, no law may abrogate, abridge, or infringe, or authorize the abrogation, abridgment, or infringement of any of the rights and freedoms herein before recognized and declared, but subject to the chapter of the Constitution and section 54, Parliament may not deprive a person charged with criminal offense of the right, listen to this one, to a fair and public hearing by an independent and impartial tribunal. Now, I've stressed upon the Constitution so far because that is the principle upon which this debate is really hinged. We're looking at the fact that our Constitution recognizes the protection of individuals, the balancing of rights, but it embraces the concept of due process, of fairness of tribunals, of independent tribunals. And when we look to the construction of the Constitution, and we look to the establishment of the fixtures of the Constitution, we of course have the executive. That begins in section 74 of the Constitution. We have the DPP, for instance, at section 90, the Ombudsman at section 91. But very importantly, we have the judiciary at chapter 7. And in establishing the Supreme Court and the Court of Appeal in sections 99 onward of the Constitution, we recognize that limb of our life, which really falls to interpret our laws. But Madam President, the bill before us seeks to amend a law which is now quite old. We are seeking to cause an amendment to the Magistrate Protection Act, Chapter 603. And here, the antiquity of this law. The Magistrate Protection Act is an Act of Parliament number 34 of 1917. We stand here 101 years later. Alongside with the Magistrates Protection Act, we had the Preliminary Inquiries Act. The Preliminary Inquiries Act was in 1917, but the Magistrate Protection Act is actually a quite short piece of law. It is across 13 sections, sections 4 and 5 in particular, and the Magistrates Protection Act itself says, look, if you're going to sue a magistrate or a justice, in this act, the term magistrate includes a justice, is what Section 2 of the Act says, the parent law. Section 3, every action to be brought against any magistrate for any act purporting to have been done by him in execution of his office shall be brought in the High Court. The existing Section 4 says that the endorsement of the writ of summons in every action, that's the method by which you sue someone, shall allege either that the act was done maliciously and without reasonable or probable cause, or that it was done in a matter not within the jurisdiction of the magistrate. Otherwise, the writ shall be set aside on summons, and if the plaintiff fails at the trial to prove the allegation, a verdict shall be given for the defendant. Section 5 says, any person injured by any act not done by a magistrate in a matter not within his jurisdiction or in excess of his jurisdiction, or by any act done or in any manner under any conviction or order made by warrant issued by him, may maintain an action against the magistrate without alleging that the act complained of was done maliciously and without reasonable and probable cause. Those are the two sections of the existing law. Translated into from 20th century, 19th century language into 20th century, because this law comes from the English Justice Protection Act of the UK. That's an 1848 law. So the 1917 Trinidad law is based upon 19th century English law of 1848. In 1917, we cast two particular sections, Sections 4 and Section 5. And these sections have been applied in the courts of Trinidad and Tobago. And in the courts of Trinidad and Tobago, and I'll come to the jurisprudence a little bit later on, we have come to the position that magistrates and justices have limited immunity. And the limited immunity is grounded in an understanding of Section 4 and Section 5. So who's a magistrate? Who is a justice? That's an important question for us today in seeking an amendment to the law. A magistrate is actually a creature of statute. A magistrate is someone who fits the position of the Summary Courts Act, in particular Section 3. And I want to take us there. The Summary Courts Act is Chapter 420. And when we look to Section 3, this is what it says, general provisions. There shall be such number of magistrates in the public service as may be required for the purposes of this Act. Every magistrate shall be ex officio a justice of the peace of Trinidad and Tobago. And then 3A, capital A, goes on to say the qualifications for a magistrate. No person shall be appointed a magistrate unless he has been admitted to practice as an attorney at law in Trinidad and Tobago and has practiced for not less than 5 years, etc. A magistrate under 3B is someone to be appointed by the Judicial and Legal Services Commission. Who is a justice? A justice is to be found by way of reference to the Indictable Offences Preliminary Inquiry Act. This was again Act number 12 of 1917. Just a couple acts in the same year that the Magistrates Protection Act was passed. And justices are not justices of the peace, as the Interpretation Act sets out. Justices, in fact, are the persons that occupy the office of the clerk of the peace. Justices are, under the preliminary inquiries law, entitled to carry out the functions of magistrates as it relates to certain things. And that's to be found in Section 2.2, where it says, for the purposes of this Act, justices shall have and exercise concurrent jurisdiction with the magistrate to issue summonses, warrants, other processes of the court, to grant bail and to fix the amount, to take recognizances, and to bind over parties and witnesses, and to administer oaths. So, Magistrate is a creature of statute. Magistrate is to be found under the Summary Courts Act. Magistrate is not found in the supreme law of Trinidad and Tobago, which is the Constitution. The Constitution provides for the High Court and the Court of Appeal, and in fact the Privy Council. Magistrates are equal to justices in certain parts, or rather justices exercise concurrent jurisdiction with magistrates, so determined under the Indictable Offences Preliminary Inquiries Act, and justices are not justices of the peace. So in 1917, the position was that Trinidad and Tobago was arranged very much in a very convenient way to administer justice. Effectively, we had our courts at the higher court level, and we had magistrates who were really people that administered justice in the hinterland, if you wanted to call it, in districts or divisions of Trinidad and Tobago. In Trinidad and Tobago, the position is that magistrates are now full-time, frontline persons entrusted with the administration of justice. The statistical information to be found in relation to magistrates can be found in the judiciary's latest annual report called Improving Court Services Through Process Reform, the annual report of 2017 and 2018. In particular, and in commending the judiciary for an excellent publication, one has very good reading at section 10 at page 52 onwards. So who is our magistracy today? The magistracy is comprised of 12 magisterial districts, as per the Summary Courts Act. Magistrate districts operate with a distribution of 18 magistrates' courts. There are 46 members of the magistrates' court. There's 1 chief magistrate, 1 deputy chief magistrate, 8 seniors, 36 magistrates. Listen to the case volume of what magistrates treat with. Magistrates in the year 2017 to 2018, the total number of cases filed in the magistrates' court stand at 165,154. Listen to what magistrates deal with. Capital offenses, 168. Domestic violence, 8,332. Petty civil, 1,350. Private summary matters, 8,242. Ejectment, 772. Inquests, 797. Non-capital offenses, 28,186. Family matters, 14,532. And traffic, of course, 102,875. The disposition rates in 2017-2018, capital, we've only disposed of roughly 40% per year. 60% goes into backlog. Non-capital, we dispose of roughly 50%. 50% goes into backlog. Family matters, better statistics, we have about 70% disposition, 30% goes into backlog. Domestic violence, 30% goes into backlog. Traffic, 46%, 50% go into backlog. Ejectment, 70% go into backlog. Inquests, 98% go into backlog. What do our magistrates treat with? Magistrates in today's world, not 1917, treat with summary offenses. Preliminary inquiries, in particular, if I look at the criminal jurisdiction of the magistrate's court. Summary offenses are matters which the magistrate has exclusive jurisdiction over. The magistrate is the arbiter of fact, and the magistrate applies the law and comes up with a decision. Of course, there are rights of appeal coming after that. Indictable offenses are offenses which pass through a preliminary inquiry, where a magistrate sits to see if there's a sufficient case. If there is a sufficient case, the magistrate says, you will go to the High Court in the assizes, and a judge will apply the law, and a jury will consider the facts. Unless, of course, you choose a judge-only route, which we have only now introduced into law. In the magistrate's court, these are current laws that magistrates apply. Listen to this one. The Anti-Terrorism Act, Section 15C. Failure to give notice that you're traveling to a declared geographical area. A magistrate shall consider that on summary conviction, a fine of $50,000, a term of 2 years. Again, in the Anti-Terrorism Act, notice of traveling with a child to a geographical area. Summary conviction, fine of $25,000, imprisonment for 3 years. Duty of parents, summary conviction, fine of $25,000, term of 3 years. Offenses and penalties, breach for listed businesses, a fine of $500,000, imprisonment for 2 years. We go on to the financial obligations, financing of terrorism, summary conviction, under the Proceeds of Crime Act, where we treat with money laundering, which is a scourge of criminality in our jurisdiction. Section 44, Section 45, Section 53. Summary conviction to a fine of $5 million and imprisonment for 5 years. We go on to the Insurance Act. The Insurance Act, listen to this one. Registrants are subjected to summary conviction to a fine of $300,000, continuing offenses $30,000 for each day. Prohibition against disclosure, registration restriction on registration. Again, summary offenses, fine of $300,000, imprisonment for 1 year. Securities Act, again, a serious issue. 156B, 165, summary offenses, $2 million, imprisonment for 5 years. Let's go further. Sections 11, 14, 54, 18, 51, 60, 90, 91, 92, price rigging, false trading, all of these things are summary offenses heard before a magistrate. Needless to say, I've just given a smattering of matters. There's the Copyright Act, there's the Trademark Act. There are multiple versions of the law where the magistrate, as the first responder, is the arbiter of facts and of law. But what we have, Madam President, is an incongruity of the law. And that incongruity of the law has been the subject of consideration in this jurisdiction and in other jurisdictions for quite some time. I recommend to honorable senators that they have a view of the excellent work by Dana Sitahal, Commonwealth Caribbean Criminal Practice and Procedure, in particular her reflections at page 8 and page 9 of the Magistrates Court, again reciting what I've just said, that magistrates are creatures of statute. Magistrates must act within the boundaries of the statute. They cannot step out of it. And particularly that magistrates don't enjoy the immunity that judges of the High Court enjoy. So we're in a position, 101 years later, where magistrates are now no longer what they were cast as in 1917, based upon the 1848 English law. Magistrates in today's world are magistrates dispensing serious justice at first instance as arbiters of fact and arbiters of the law. But in our jurisdiction, we have had exhortations from the bar, we have had exhortations from the magistracy, we have had exhortations from the judiciary asking us to look at the anomalous situation of the lacuna in the law where magistrates can be subjected to claim for damages in their personal right, where they are acting in circumstances, they are within no malice, no contempt, but maybe without their jurisdiction. So what does that mean? What does within jurisdiction and without jurisdiction mean? Well, the case law is very replete. First of all, in saying that that's a fairly straightforward yet technical consideration. Effectively, what it means to the non-lawyer is that the magistrate must act within the boundaries of the law that the magistrate is applying. Is the magistrate acting within the boundaries of the Children's Act? Is the magistrate acting within the boundaries of arrest procedures, the Summary Courts Act, the Municipal Corporations Act? If the magistrate has not acted within the strict confines of what the magistrate is permitted to do, the magistrate is acting without jurisdiction. But the current law allows for the magistrate to be subjected to a claim for liability even though the magistrate has not acted with malice or without reasonable or probable cause, as the legislation says. And of course, to the non-lawyer, what is meant by malice, what is meant by reasonable and probable cause, is a very good question. Put in its most simple term, in the simple context, malice is something which the courts have had over 100+ years of consideration as to the definition of malice. Reasonable and probable cause, again, are concepts that the courts have applied over and over again as to what an ordinary person skilled in the particular area would consider to be the standard of reasonableness for the person looking at it. The reason that there is no statutory definition for reasonable and probable cause or statutory definition for malice is because the law is allowed to speak. And in the law being allowed to speak, the task of deciding what these terms mean is the task of the judiciary. And with each judicial pronouncement, the judiciary develops what we call the common law. And the case law comes about and grows up over time to categorize what malice looks like, to categorize what reasonableness and probable cause looks like. And therefore, there is no need statutorily to define these principles because the case law and common law provides for the understanding. It must be allowed to breathe and grow and metamorphosize itself over time into a different form of being as our society itself changes over the years. So, Madam Speaker, Madam President, what tells us that we should do this? Let's start, Madam President, what time precisely do I end?
You have 1 minute.
Thank you. So let's start with the various levels of altitude. What tells us we should do this? Let's start off with an excellent piece of work. It's a report called The Status of Magistrates in the Commonwealth. It's a publication dated February 2013. It's the Commonwealth Magistrates and Judges Association. And they have given an excellent treatise saying, firstly, that the right to a competent, independent, and impartial tribunal is articulated in the Universal Declaration of Human Rights, Article 10, the International Covenant on Civil and Political Rights, Article 14, in regional treaties including the European Convention for the Protection of Human Rights and Fundamental Freedoms, Article 6, the American Convention on Human Rights, Article 8, the African Charter on Human Rights and People's Rights, Article 7. Now you know why I started with our Constitution in respecting international rights. And I'm grounding, therefore, that our own Constitution finds itself as a receptacle to receive these exhortations. They go on to speak about the UN General Assembly recognizing certain things, and they say, within the Commonwealth, the importance of an independent, integrity-led judiciary has been recognized in strengthening democratic standards and in fulfilling Commonwealth countries' commitment to the Commonwealth fundamental values. Again, you understand the relevance of starting with the Constitution. It says this: magistrates are, and I've already acknowledged this and everyone here can understand, that magistrates are usually the first and often the only point of contact for the public. We can see that by the numbers that I've referenced a little while ago, 146,000 cases. But in going through their recommendations and in their exhortations, they have come up with a very important principle that magistrates need to be protected because their immunity is something which is at risk. And this is found at page 20 of the report. It's under the heading Immunity from Suit. Magistrates shall enjoy personal immunity from civil suits for monetary damage in respect of any act done or omission made in the execution of his or her duty, or any act done or omission made in good faith in the purported execution of that duty. They say that the rationale for the guideline is that without immunity from suit, judicial officers would be less able to perform their functions independently and without fear or favor. The proposed guideline is broadly based on Principle 16 of the Basic Principles on the Independence of the Judiciary. Note that sometimes the immunity from suit is expressed in wider terms to cover criminal proceedings. In the Australian context, the immunity of magistrates is occasionally expressed as being the same of that enjoyed by justices of the Supreme Court. I ask honorable members here to bear in mind that global perspective. Let's come down to another seminal piece of work. The New Zealand Law Commission, in its publication, has gone on to consider that magistrates ought to be given judicial immunity, as they have put it, for the following reasons. Reasons for protecting, according to judicial immunity, include promoting fearlessness in the pursuit of justice and truth, ensuring that judicial function is fairly and efficiently exercised without improper interference, safeguarding a fair hearing in accordance with natural justice, which should reduce the prospect of error, promoting judicial independence, achieving finality in litigation in accordance with essential principles of res judicata, and saying that there exist adequate rights of appeal against and rehearing of review of decisions itself, therefore saying that there are safeguards in the due process route. They go on importantly to say this, and with your permission I quote, "It is not necessary to search for the reason. It lies in the right of men and women to feel that when discharging judicial responsibilities, a judge will have no more reason to be affected by fear than he will allow himself to be subjected to influence of favor." And Madam President, the limits of judicial immunity also fell into their points of consideration. They say that there should be a range of remedies available to aggrieved, reinforcing the responsibility and accountability of judges. But Madam Speaker, Madam President, we've got international and now regional fulmination as to the need to recognize a lacuna for magistrates' protection being filled, and the parity with justices in the Supreme Court and Court of Appeal context, High Court and Court of Appeal context. Where else do we go? Let's come locally. Locally in Trinidad and Tobago, we've had a plethora of decisions. For the record, Civil Appeal number P182 of 2014 from the Court of Appeal, Indar Jagru as the appellant and Anisha Mason. The panel of the Court of Appeal was Madam Justice York Suhon, Mr. Justice Ralph Narayan, Justice of Appeal, Mr. Justice Mohammed, Justice of Appeal. We have the High Court version of that, 2012, CV 2012-00129, Anisha Mason versus Indar Jagru, before Mr. Justice Raj Kumar, as he then was at the High Court. We have in the High Court, again, Civil Appeal, CV number 2010-2754. This is Alastair Manzano versus the Attorney General, before Mr. Justice Ricky Rahim. We have in the Court of Appeal, Civil Appeal number 45 of 2000, which is Myrtle Creville in the estate of Clyde Creville versus the Attorney General. The panel was very distinguished: Mr. Justice of Appeal Kangaloo, Mr. Justice of Appeal Mendonça, Mr. Justice of Appeal Beru. And lastly, we have in P028 Civil Appeal of 2015, the Attorney General and Mrs. Lisa Ramsumer Hines and Russell David, comprising a panel of the Honorable Chief Justice, Mr. Justice Ivor Archie, Mr. Justice of Appeal Nolan Barrow, Mr. Justice of Appeal Peter Rajkumar. And the one that I think really takes us to the crux of this debate is the first case, Indar Jagru and Anisha Mason in the Court of Appeal. And I want to put onto the record that the Court of Appeal considered some landmark decisions, in particular 3 of them coming from other jurisdictions. The 3 jurisdictions, of course, included consideration of the following cases. McSee versus Mullen and others, that's a House of Lords decision of 1984. There was the case of McCready. Again, that is a case of July 13th, 1907. And then the last case is to be found in Cyrus versus Moore, which is a 1972 case reported in 1974, and I'll come to the dicta of Mr. Justice of Master Rose Denning in that particular case. But suffice it to say, in our own jurisdiction, having looked at those 3 cases, this is the very relevant position to be found at paragraph 28 of that judgment. And here's what Mr. Justice of Appeal Ralph Narayan is saying to us, effectively, the legislature. Paragraph 28. It follows that we have found no merit in this appeal. However, we must express our concern for the position in which a magistrate is held personally liable for his actions while presiding on the bench in a situation where he has acted without or in excess of his jurisdiction, but without malice of any kind. The injustice that may arise in such a case and the need for legislative intervention was recognized by the House of Lords in McSee versus Mullen, and I'll come to that in a moment. And then they went on to quote the dicta of Lord Templeman in that particular case. So our own Court of Appeal tells us that in 2012 and in 2014, there's a lacuna in the law. The legislature, starting with this Senate, ought to consider filling that. And I'm able to say that I have received correspondence from attorneys at law acting in the matter of the Jagru case, senior counsel and eminent junior counsel, who wrote to me as Attorney General complaining that notwithstanding the fact that they had written my predecessor in office as Attorney General in 2012, in 2013, in 2014, that nothing was done in terms of treating with this, and that the magistrate was effectively going through an indignity of having to beg the state to give the magistrate an indemnity for actions. And I might add that that indemnity was never given in this particular case. So without amending the law, the Court of Appeal says that the judiciary should tell the legislature to have a look at this. The executive has been approached 2012 to 2014 under a previous government to do something about this. A request for an indemnity was made. The then sitting Attorney General Ram Logan did not grant the indemnity, and the magistrate had to worry about the position going forward. So where do we come to now? I'd like to put on the record the very important exhortations coming from the cases relied upon in our jurisdiction. And those are the three cases that I've just referred to. That's McSee versus Mullen, that's McCready, and that's Cyrus. And the one that I really find most emphatic is really the words coming from Lord Denning. And I'd like to read this into the record with your permission. This is to be found at page 136. Here's what Lord Denning had to say about the modern courts. In the old days, as I've said, there was a sharp distinction between the inferior courts and the superior courts. Whatever may have been the reason for this distinction, it is no longer valid. These are words from Denning in 1975. I was 4 years old at the time. There has been no case on the subject for the last 100 years at least. And during this time, our judicial system has changed out of all knowledge. So great is this change that it is now appropriate for us to reconsider the principles which should be applied to judicial acts. In this new age, I would like my stand on this, to take my stand on this. In this new age, I would like to take my stand on this. As a matter of principle, the judges of superior courts have no greater claim to immunity than the judges of the lower court. Every judge of the courts of this land, from the highest to the lowest, should be protected to the same degree and liable to the same degree. If the reasons underlying this immunity is to ensure that they may be free in thought and independent in judgment, it applies to every judge, whatever his rank. Each should be protected from liability to damages when he's acting judicially. Each should be able to do his work in complete independence and free from fear. He should not have to turn the pages of his books with trembling fingers, asking himself, if I do this, shall I be liable in damages? So long as he does his work in the honest belief that it is within his jurisdiction, then he is not liable to any action. He may be mistaken in fact. He may be ignorant in law. What he does may be outside his jurisdiction in fact or in law. But so long as he honestly believes it to be within his jurisdiction, he should not be liable. And Madam President, I think that those words in 1975, as put in writing by none other than Lord Denning himself, I think that these words are equally appropriate and applicable so many years in Trinidad and Tobago later. Cyrus and Moore was that case. Denning. There's a very interesting one, which is McSee and Mullen and others, and I want to refer to the last page of that again to see the record right. And these are the words of Lord Templeman. Lord Templeman, in going through his position, says, in reflecting upon these words, he put to record this: this appeal demonstrates that the time is ripe for the legislature to reconsider the liability of a magistrate and the rights of a defendant. Again, this is a decision of the House of Lords, 1984. We have our local jurisprudence relying upon the foreign jurisprudence. There's a plethora of law coming in particular out of Jamaica, which is equally persuasive. The Supreme Court of the Judicature of Jamaica, full court in their case of Brenton Henry, which is 2016 Jamaican full court, to be found there. That case again recited the law as it appears in the three cases that I've referred to in England. So where are we in the round right now? The bill itself proposes, in repealing and replacing sections 4 and 5 of the Act, we propose specifically that we have something to hold on to which allows us an improved condition. The improved condition in the new clause, in inserting a new section 4 as the clause proposes, is that no action shall be brought against a magistrate for any act done by him in the execution of his office in relation to a matter within his jurisdiction. So we are saying here, the magistrate must act within his jurisdiction. We are going on in the new version of Section 5, should the Senate agree to it, to say, in subsection 5.1, a person may maintain an action against a magistrate for any act done in a matter not within his jurisdiction or in excess of his jurisdiction where it is alleged and proved that the act was done maliciously and without reasonable and probable cause. So, the new Section 4 says no action at all if you're inside of your jurisdiction. You've complied with the statute that the magistrate is exercising consideration upon. New Section 5 says if you are outside of your jurisdiction or in excess of your jurisdiction, but that you did not act maliciously and without reasonable and probable cause, well, then you are exculpated. This is recommending a standard which judges enjoy. This is recognizing where we are in terms of our administration of justice, in having a parity between magistrates exercising serious responsibility under the many laws that I referred to, Proceeds of Crime Act, indictable offenses, securities, insurance, copyright. Magistrates are exercising significant responsibility. But very importantly, I ask this Honorable Senate, and in particular I now speak through you, Madam President, to our new independent senators. One is obliged to take note of what this 11th Republican Parliament has purchased already. We have taken two very important pieces of law and added one very important subsidiary law into the mix. The subsidiary law I refer to is the criminal proceedings rules. They actually have two versions of them for our children in the children's criminal court arena and the criminal proceedings rules. And very importantly, we have the Family and Children Division Act, which created a division of the family court and children's court, where all crimes to be dealt with in respect of children, people under 18 years, are dealt with in a specialist court. And in that specialist court, there is a merger of jurisdiction between a judge and a magistrate, a master and a magistrate. And then we did something for the adults in the criminal court, the criminal division and traffic division. And in that, We took for all people 18 years and above an exact approach as we did for the children and created a division of court. So there's a concurrence of jurisdiction running alongside masters and judges and magistrates, family and children division, criminal division. We have rules of court in effect. It would be an absurdity if we were not to apply a similar standard of immunity. And therefore, it is not only within the meaning of the preamble of our Constitution or Section 5 of our Constitution as the supreme law. It's not only within the architecture of the Constitution where we recognize the sanctity which our judiciary ought to hold in providing for a High Court, Court of Appeal, and Privy Council.
Attorney General, you have 4 minutes.
Thank you, Madam President. But it is also in keeping with the logistics of the reform of justice, because as we go into hyperdrive now, as we go into bringing more and more cases into the summary court arena, we need to make sure that our magistrates can act without fear or favor, malice or ill will. And I ask honorable senators, would we speak the same way in this chamber if we did not have Section 55 of the Constitution? Section 55 of the Constitution gives each one of us as serving parliamentarians a privilege and immunity from criminal and civil proceedings for anything we say and do in this parliament, including our committees, so that we may act with a freedom of speech and privilege without fear, favor, malice or ill will in the discharge of our responsibilities. How do we apply a lesser standard to our magistrates is the question. We have modeled our law behind a few jurisdictions. We've looked to Bermuda, we've looked to the United Kingdom, but very importantly, in adjusting our law, we've looked to the dicta of our own Court of Appeal in the many judgments that I've recited. So, Madam President, I am to say now, the law is proportionate, it is rational, there's a legitimate aim, it addresses a mischief which is in need of address. It has stood on the books from 1917 to 101 years later in 2018 as it now stands. Our courts have made an exhortation echoing the type made by courts in other jurisdictions. The Commonwealth Association of Magistrates endorses this. The fora convened in New Zealand address this. And I think that I can also say that our own magistrates have asked for this. And that is to be found in their own correspondence and in some of the advocates for their cause. I look forward to submissions from honorable senators this evening. I know that we are bringing you close to the edge of the month of December because I know that we have another bill yet to treat with in the Senate. But I do look forward to the contributions coming from members so that we can together work on creating good law for the benefit of Trinidad and Tobago. I beg to move.
Honourable Senators, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Magistrates Protection Act, Chapter 603, be now read a second time. Senator Mark.
Yes, Madam President, like our distinguished and Honorable Attorney General, we too are committed to making good laws that is proportionate, legitimate, and have some degree of rationality. Madam President, like diamonds, you have to dig deeply sometimes beneath the surface to really discover its real value and significance. And we on this side have done some drilling down into this piece of legislation. And I want to tell the Attorney General from the outset that we are with him in attempting to ensure that judicial officers, in this instance, magistrates, can go about their business fearlessly. They can go about, Madam President, doing their job without any let or hindrance. But I am happy that he made reference to Section 55 of our Constitution, because I can speak, as you know, in this Parliament, and I do have protection within this jurisdiction. But if I accuse someone, if I libel someone, and I escape your wrath, I dare not go outside of the precincts of this chamber and repeat it in the public. Because if I go on the pavement, like the Prime Minister is threatening us to go, I can tell you, Madam President, charges will be brought against me, meaning that I have acted outside of my jurisdiction. So let us get this thing clear, Madam President, that we are in favor, and I agree with the Attorney General, Madam President, that even when he referred to Lord Denning, repeatedly, one of the things that he kept saying over and over is within one's jurisdiction, within one jurisdiction. Honestly believe that you are acting within one's jurisdiction. That is the critical point that we need to pay attention to. You cannot go outside of your jurisdiction, Madam President, either excessively or in a malicious manner, without probable and reasonable cause, as we are advised, and take action and not to expect consequences, Madam President. So, Madam President, we go to the 1917 law, which is 101 years of age. And the drafters and framers, the colonial persons who were in charge of the country at that time, they formulated legislation. And, Madam President, they offered a right to the citizens of the colonial period. And as you know, and we have always been advised, under our Constitution, Section 6 of our Constitution, you have saved law. And this is a piece of saved law. That is the Magistrate Protection Act of 1917. Madam President, I want to share with you what the 1917 law says. Because no one can argue, as I said, with the protection of a magistrate from personal liability, Madam President. We want to join with the government in seeking to give that magistrate a protection that currently does not exist. But there are some concerns, Madam President. Madam President, in Section 4 of the Magistrates Protection Act, which is being repealed by the amendments before us, does provide protection for the magistrate. And if I may share with this Honorable House briefly what this does and what it says, Madam President, it says that in the endorsement of the writ of summons in every such action shall allege either that the act was done maliciously and without reasonable and probable cause, or that it was done in a matter, or manner, I should say, not within the jurisdiction of the magistrate. Otherwise, the writ shall be set aside. So, Madam President, what this section of the legislation is saying is that once the magistrate has acted within his or her jurisdiction and not without or in excess of his or her jurisdiction, and it is not malicious or it is not without reasonable and probable cause, you cannot take action, Madam President, against a sitting magistrate. That is clear. That is what Section 4 says. So the magistrate does enjoy that protection. What causes a problem, Madam President, is Section 5 of the Magistrates Protection Act. And what this section says is that any person injured, Madam President, we are talking about John Public. We are talking about the ordinary man in the streets of our nation. Section 5 is stating that any person injured by any act done by a magistrate in a matter not within his jurisdiction or in excess of his jurisdiction, or by any act done in any such matter, under any conviction or order made or warrant issued by him, may maintain an action against the magistrate without alleging that the act complained of was done maliciously and without any reasonable or probable cause. Madam President, this is what Section 5(1) is saying. You know, the government is seeking, Madam President, to have us today repeal this section. Madam President, we are being asked to repeal this section. So we are being asked, Madam President, to allow the magistrate a free hand in excessive action without that person's jurisdiction, and if that person is acting in a negative fashion. So the government is asking us to remove that provision. So whereas now, Madam President, I can take action against a magistrate who might act outside of her or his jurisdiction, in excess of his or her jurisdiction, Madam President, and I don't have to prove, Madam President, malice. I don't have to prove that, Madam President, or allege any act done without any reasonable or probable cause. What the Honorable Attorney General is now proposing under Section 5(1), which is repealing, Madam President, he's now saying that the ordinary poor individual who a magistrate has taken action against outside of his or her jurisdiction and without probable reasonable cause, we are now being told, don't take any action against the magistrate. Madam President, I do not have to prove at this time, as an ordinary member of the public, maliciousness on the part of the magistrate. I don't have to prove at this time probable or reasonable cause at this time under Section 5(1) of the Act that we have before us. Once the magistrate, Madam President, like I, go out of these four walls and accuse someone in a libelous way, I can be charged. That is why any member of parliament can challenge me and say, repeat it outside, because you have protection inside. You know why they challenge me to repeat it outside? Because I do not have the protection of the law outside of this parliament. So, Madam President, why should anyone be allowed to operate outside his or her jurisdiction? Why must someone be allowed to be given the power, whimsically, arbitrarily, to act outside his or her jurisdiction, and then there is no penalties attached? This is what the Attorney General is asking us to do today, to allow a judicial officer, not within the law, Madam President, not within the law. If it is within the law, we support that. But, Madam President, you are telling us, go outside of the law. And, Madam President, the Honorable Attorney General has drawn reference to many cases, both internationally, regionally, and nationally. And he spoke about Indar Jagru and some person called Anissa, I think, what's his name? Anissa, I forget the name of the individual. But that's a case, Madam President. Mason, Madam President. And what happened, Madam President, as you would recall, is that the magistrate, there was a custody matter. And the magistrate was told by some individual who did not want that child, who was under 17 years at the material time, to be in the home, the marriage home, because the child was given trouble. But the child did not commit an offense, Madam President. And you know what happened? The magistrate took it upon himself, even though he didn't have the power under the law to remand that child at the Golden Grove prison for almost 5 months. And the child did not commit an offense. Well, they took action against the magistrate. And both at the level of the High Court, Madam President, and the Court of Appeal, the magistrate was found to have acted outside of his jurisdiction. So, Madam President, how can you act outside of your jurisdiction and expect a blind? Madam President, we will be encouraging misfeasance, malfeasance, we will be encouraging abuse of office, and we cannot, as a parliament, become party to any such action or development. We can't. How can we be called upon to do that? Madam President, may I also advise, as I understand the law, I know you're a lawyer, and if I'm going wrong, you'll advise me. Madam President, as I understand it, if currently I enjoy a right, and I can take a magistrate, Madam President, who has acted outside his or her jurisdiction and has sent me to prison, and the magistrate has no power to do so, Madam President, I can take action against that magistrate. If the magistrate sends me or any one of us in this parliament to prison and the magistrate doesn't have the power to do so, I have the power to take action against the magistrate. That is what Section 5.1 allows me to do as a citizen of this republic. So I now enjoy a right as a citizen. It was passed in 1917, December 1917, 101 years ago. We are now in 2018, Madam President, 101 years later. You want to remove my right as a member of the public. If you are removing my right as a member of the public, then you have to bring a special constitutional majority and attach a certificate to the bill that you have before me. Because, Madam President, you are aware, I am no lawyer, but I've been in this parliament for a few years, so I have been doing law. And Madam President, I am seeing in Section 6 of our Constitution, where it talks about exceptions for existing law. And under that section it says, Madam President, if you are repealing or reenacting with modification an existing law and is held to derogate from any fundamental right guaranteed by Chapter 4 and 5, or the chapter that I'm dealing with here, in a manner which or to an extent to which the existing law did not previously derogate from that right, then subject to sections 13 and 54, you are subject to section 13 and 54. So the Attorney General is trying to derogate, whittle down, diminish a right that we currently enjoy, Madam President, under SAVE legislation in section 6 of our Constitution. And if the Attorney General is seeking to do so, then once you are whittling down my rights or any citizen's right, then you are violating sections 4 and 5 of the Constitution, and you require a special constitutional majority to pass the legislation. Madam President, yet the Honorable Attorney General has brought legislation today that says it's a simple majority, but it is taking away the citizens' rights. You cannot take away citizens' rights that they currently enjoy and do not attach a certificate that says you need a 3/5 majority. You cannot do that because this is saved legislation. So, Madam President, it is baffling me why we would want to go down that particular route. So, Madam President, I was looking at what is called Halsbury laws. And Halsbury law, in the context, Madam President, of what we are dealing with, in terms of what is called judicial privilege and the nature of protection, they identify in their publication, I only got one page of it, a bit thick, so I took one page, sir. Ma'am, I think I better go and study law. Yeah. So, Madam President, under Halsbury law, it states, and I think just for the record, it's a very short piece, Madam President. I want to share it with you and this Honorable House. Because, you know, it tells us what protection really means. And when you talk about privilege and the nature of privilege in the context of protection, what it means in the context of a superior court of law and an inferior court of law. So, Madam President, what it says is this, and I quote, wherever protection of the exercise of judicial powers applies, it does not matter that the judge was under some gross error or ignorance, or was actuated by envy, hatred, or malice. The protection applies provided the judge acts in the exercise of his office and in the belief, though mistaken, that he has jurisdiction. So even a judge, Madam President, once he has the belief that he's acting judicially and within his jurisdiction, he is covered by immunity, according to this definition. It goes on, Madam President, to say the rule applies differently to superior and inferior courts. And I quote again, Madam President, a superior court where judges are located is protected even though the judge has exceeded his jurisdiction, so long as he has acted judicially. This is what Halsbury law is saying. So it's not to say that the judge escapes, you know, Madam President, from liability. Once the judge can prove that he is lying, I beg your pardon, Madam President. Once he can show that he has acted rather judicially, he is in good stead. And it goes on, Madam President, to say an inferior court, such as a magistrate's court, which exceeds its jurisdiction, is not protected. It is not protected unless the exercise of jurisdiction was caused by an error of fact in circumstances where the court had no knowledge of or means of knowing by the relevant facts. And Madam President, it says, and I close by this statement or sentence, a court which has jurisdiction is protected even where it proceeds irregularly within that jurisdiction. So once you have jurisdiction and you even exceed that jurisdiction, once there is a belief, Madam President, according to this definition, in the case of a judge, and the belief is that the judge was acting judicially, then that judge is protected and has that privilege of protection from any attempt at bringing any motion or action against him. That is not so, Madam President, with the lower court, or what is called the inferior court, which is the magistracy or the magistrates court. So, Madam President, what we are saying on this side is either the government brings a special majority this evening, or they leave the law as is, and we would like to propose an appropriate amendment for the government's consideration so that we can ensure that the magistrate, when action is taken against that magistrate, Madam President, that magistrate doesn't have to go in his personal pocket to sell his home or his property. We have to protect the magistrate. And I support that, and we support that here. We do not believe a magistrate should be personally liable. So we are with the Attorney General on that, Madam President. But what we have a difficulty with is the Attorney General seeking to take away, to abrogate, to violate, to breach, to remove, Madam President, a right currently enjoyed by the ordinary man and woman in our society. We cannot be in support of that. Madam President, you have been in the courts like so many of our lawyers here, and I have been advised by those lawyers that the hardest thing to prove in a court is malice. Malice is a very hard thing to prove in a court. And something called probable and reasonable cause. What is that, Madam President? You are asking an ordinary man who cannot even get money to pay a lawyer. He has to go through what is called legal aid. You are asking him if a magistrate takes action in excess of her jurisdiction against him. You are telling him, listen, prove, Madam President. Right now, he doesn't have to prove anything, Madam President, under 5.1. He has nothing to prove. But you are now saying, listen, we are amending the law. And the law is being amended to say, ordinary man, if you want to take action against a magistrate, forget the magistrate has acted outside his or her jurisdiction, you know. Forget that. That doesn't arise. The magistrate can do anything. In other words, Madam President, what we are being told today is that we must put the magistrate in this country above the reach of the law. The magistrate cannot be above the reach of the law. Everybody must be subject to scrutiny, and nobody is above the law in Trinidad and Tobago, including a magistrate, Madam President. So what we are being asked here today, Madam President, to do is to put pressure on the small people in order to satisfy the interests. As I said, Madam President, I have nothing against magistrates. We in the opposition have nothing against magistrates. We believe that they should not be personally liable. We support that. They shouldn't go in their pockets to pay. But do not remove the right of the ordinary people to take action against a magistrate if that magistrate exceeds his or her jurisdiction. And therefore, what we are proposing, Madam President, we are proposing for this Senate's consideration the following amendment. we are advancing. You leave the law as is at this time. Do not touch Section 5(1) of the law. And we are saying, leave the law as it is. What we are saying, Madam President, we want to put a new Clause 5, and the new Clause 5 is going to read, where in any claim brought against a magistrate in the execution of his duties, any order is made for damages or cost, such order shall be met out of the consolidated fund. We are proposing that that be a direct charge on the public purse. So we allow the magistrate, Madam President, not to be liable personally for any liability. That is what we are suggesting for the consideration of this Honorable House. But we refuse to support any measure that is going to diminish the rights of our citizens to take action against any magistrate who happens to exceed his or her jurisdiction. And people end up in prison as a result of those actions on the part of the magistrate. Madam President, you would agree with me that there are many challenges that our magistrates face today. Madam President, even the Attorney General has brought to our attention the amount of cases. In fact, I think the Attorney General quoted in his opening, over 165,540-something cases went before the magistracy in the year 2017, 2018, according to some report he quoted from. Madam President, and he went on further to desegregate, disaggregate those cases in terms of capital, non-capital, traffic, and a number of other, family included. And he was able to share with us the load, the backlog, 40%, 30%. In the case of inquest, he said 98%. So, Madam President, what is happening is that there is a complete breakdown in the quality of the administration of justice in our country. So we know delays are contributing towards the administration or the challenges faced by the administration of justice in our country. We know, Madam President, that the magistracy, right, they are faced with all kinds of challenges. They work long hours, Madam President. They get poor remuneration packages. They are underpaid. They need training, Madam President. They need more security. They need better accommodation, Madam President. Madam President, if you go to some of these courts today, they are worse than pigsties. I mean, so you go to these courts today, and no funds, Madam President. And we are saying, while the government is bringing this measure to deal with the magistrate in terms of protecting the magistrate against personal liability, the Attorney General needs to pay attention, Madam President, to what is happening at the level of the administration of justice in our country. And these are issues that we have to pay attention to, Madam President. So, Madam President, we are arguing on this side that the government needs to do some homework. Go back to the drawing cards or the drawing table, Madam President, and come up with something that is more acceptable and meaningful. So, Madam President, if we go again to the legislation that is before this Honorable House, you would see that in Clause 3, the government is amending Section 4, is repealed and replaced. And we are being told that, as you have been noted, and you have noted, that no action shall be brought against a magistrate for any act done by him in the execution of his office. in relation to a matter within his jurisdiction. Madam President, as I said, you cannot argue with that, and I cannot argue with that. But what we cannot understand, what we couldn't appreciate and fathom, is this attempt by the government. Maybe, as I said, Madam President, they didn't think it through properly. I want to ask the Attorney General, Madam President, through you, did they consult with the Law Association on this matter? Who did they really consult on this matter? We know, Madam President, from the cases that we have looked at, that the High Court, the Court of Appeal in particular, have been making overtures to the legislature and to the Parliament to look at this whole question of personal liability. We know of the case in the House of Lords in which a similar appeal was made. So we know that that is a matter that has been out there for some time. And we are trying to see how we can rectify that situation, Madam President. But we cannot really deal with it in the way that the government is attempting for us to deal with it at this time. Madam President, we know that historically, as I said earlier, judges have been protected because of the need to allow them to exercise their duties, and like the magistrate as well, without fear of personal liability. And therefore, we want that to continue, Madam President. So, Madam President, in a nutshell, we would like to submit, in summary, our concern as I wrap up. We on this side would like to work with the Attorney General and the government to deal with the lacuna in the law as it relates to magistrates being exposed to personal liability. We have proposed an amendment to achieve such an objective. Madam President, we object very strongly and vehemently to any decision or action on the part of the government to reduce and or diminish the rights of the ordinary citizens at this time. If the government wishes to pursue that course of action, we are calling on the government to insert a certificate of 3/5 majority in the current legislation. So we are therefore advising the government, Madam President, leave the law as is and just include this amendment so that when action is taken against a person, Madam President.
Senator Mark, you have 5 more minutes.
Thank you very much, Madam President. If any action, Madam President, is taken against a sitting judicial officer, in this instance, a magistrate, then that right would be available to any citizen who feels aggrieved. And Madam President, you would know that when you go to a court, you feel intimidated, you know, because of the kind of the environment that you are in. You have a magistrate here who feels she's very, very powerful, or he or she feels very powerful. And sometimes, Madam President, decisions can be taken in a whimsical and arbitrary fashion. And in those circumstances, when you take arbitrary decisions, Madam President, there's a case which an individual won. He went before a magistrate, and he said he uttered some words, and he walked out. And the magistrate apparently was upset over the fact that he uttered words that the magistrate didn't like. He walked out, and then the magistrate brought charges under a particular part of the act, and that person was held in contempt of court. Well, that person took the magistrate to the High Court for violation of his constitutional rights to liberty. And you know, Creville case, and he won the case. So, Madam President, you cannot immune or you cannot place the magistrate as what we are trying to do in a sacred chamber and say you can do whatever you want. There will be no power. There's nothing that we are putting in the hands of the ordinary people to stop you. And this is wrong. And I think any rational, informed individual understanding what we are dealing with here today cannot in good conscience agree with the amendments that we are being asked to support today. We cannot support the amendments in its current form. We are with the government to strengthen the immunity, to strengthen the protection given to the magistrate, but we cannot do so whimsically, arbitrarily, at the expense of the rights of the citizens of our republic. And this is where we part ways with the government on this particular measure that we have before us. We, in closing, Madam President, we are prepared to work with the government to tighten the legislation, to amend where it's necessary, but we cannot support the legislation in its current form. You will not get the support of the opposition if you decide to go through the bill as it is, Madam President. With those few words, Madam President, I thank you for allowing me to speak on this matter. Thank you very much, Madam President.
Senator Vieira.
Thank you, Madam President. Madam President, I remember vividly the very first time I went into the court of former magistrate, His Worship Mr. Ian Sukaran. This was in Tunapuna in the early 80s. I was a young lawyer at the time. And I recall vividly the crowded courtroom, the murmured voices, lawyers sitting at the bar table all queuing up to have their turn, police prosecutor at the far end of the corner. And at the center of it all, gavel in hand, holding everything together and moving things along, the presiding magistrate. Now, Mr. Sukaran, like many other magistrates then and now, he was a sheriff of his town. He appeared to know all the characters coming up before him. And he dispensed community justice with a mixture of fairness, compassion, and pragmatism. Perhaps a stern tongue lashing and a warning, perhaps words of inspiration and some guidance, perhaps a fine, but always, always with the intention of achieving a fair and just result. So, Honorable Attorney General asked, what do magistrates do? Well, not much is said about them in the Summary Courts Act. The definition section says, a magistrate includes a magistrate appointed on contract. Section 3 says, there shall be such number of magistrates in the public service as may be required for purposes of the Act. And Section 3A says that no person shall be appointed a magistrate unless he has been admitted to practice as an attorney at law in Trinidad and Tobago and has practiced as such for a period of not less than 5 years. But none of that really conveys the full picture. Magistrates are the foot soldiers of our judiciary. The Attorney General said they are full-time frontline persons. They dispense justice within their districts and their communities. As community leaders, knowing all the persons appearing before them, and tailoring their orders and decisions to suit. The magistrate's court is where the average citizen finds himself when he gets into trouble with the law or he has some problem that he needs to have resolved. Mothers demanding milk money, delinquent youth in need of discipline and guidance, persons charged with the possession of drugs, traffic violations, and other summary offenses, cattle trespass and unclaimed animals, offenses in streets, and the control of music in public places. drunk and disorderly behavior, setting bail, preliminary inquiries, coroner's inquests. Magistrates handle most criminal cases and more. They are indeed the stewards who shape and protect our local communities. And sometimes making decisions reflective of the local community requires a certain bending of the rules or making a chancy judgment call with the inherent risk that you may not have gotten it quite right within the strict limits of the law. I have come to respect and admire many magistrates. They are critical to our legal system. In 1924, Lord Haldane, then Lord Chancellor, in his presidential address to the Magistrates Association, spoke on the attributes he felt that were essential in a good magistrate. He said, "What I want of a magistrate is a God-fearing person of a just mind and fair outlook, who does not seek what are the politics or the social position of the people before him, but will try to come to a just conclusion." And in his address to the Magistrates' Workshop in October 1978, His Excellency Mr. Ellis Clark, President of the Republic of Trinidad and Tobago, said, "On our magisterial bench, we want men and women of character, men and women who command, not because of the fact that they are magistrates, but because of themselves, the respect of the people who appear in court, so that people appear before them with confidence, knowing that there will flow from them, as from a pure fountain, the clear water of justice." Many of our magistrates have been elevated to high position. Judges of the Supreme Court, President of the Industrial Court, Chairman of the Tax Appeal Board, Ombudsman, Chairman of the Integrity Commission, all were once magistrates. So these are people of ability, and indeed, our country has been blessed in having such good and faithful servants. Now, as we have heard, the Summary Courts Act was passed in June 1918, over 100 years ago. And by and large, apart from decisions being appealed to the Court of Appeal, the system pretty much functioned without challenge. But all of that changed in July this year, when the Court of Appeal gave its decision in the case of Jagru and Mason. We have heard of Jagru and Mason, both the Attorney General and Senator Mark talked about it. This case highlights a chink in the armor of the court, specifically that a well-intentioned magistrate acting outside the scope of his powers can be sued and may be personally liable. Now, obviously, this can and it will have a chilling effect on all those who administer justice in the summary courts. Our magistrates are called upon at times to handle complex and difficult cases, complex and intricate in terms of the law, and difficult in terms of the situation itself. And in Jagru, which I'm going to go into in a minute, the magistrate found himself in a genuine conundrum. Before going to Jagru, I just want to say our magistrates have little or no support. They don't earn a lot of money. They have families to provide for. The last thing they need is to find themselves as defendants in a court in civil suits for acts done by them, even when well-intentioned and done in good faith, in respect of matters outside of their jurisdiction. Even if they succeed in defending the action, the potential liability and the likely costs involved will be off-putting. Our magistrates don't deserve to find themselves in such a situation. The threat of personal liability can and will also undermine the administration of justice. Certain interests may seek to intimidate and thereby pervert the course of justice by subtly, and sometimes not so subtly, intimating that unless the magistrate does this or orders that, he will find himself in court having to answer claims for damages. I could hear the voices. If you only do that, we're going straight to the High Court. Now, what happened in Jagru? In the Jagru case, the magistrate had been ordered by the High Court to pay damages for false imprisonment. The claimant, as we have heard, having been repeatedly remanded to the woman's prison at the Golden Grove in Aruca. The trial judge found that the claimant was entitled to damages as the magistrate had no jurisdiction to commit her to prison and that he was not immune from suit. But it was not disputed that the magistrate was only trying to help. The situation arose under a fit and proper custody application, where the magistrate was informed, among other things, that the 17-year-old girl was beyond control. The child's conduct was disruptive, and she was not wanted at home, as it was damaging her father's marriage. The magistrate concluded that the child could no longer stay at home with the family. And what did he do? He made inquiries. He made inquiries with respect to safe houses and children's homes, including the St. Jude's home and other relatives of the child. All inquiries proved to be unfruitful. So on that basis, he adjourned the matter and remanded the child to the woman's prison. It was not in dispute that the child was never charged with any offense, that the magistrate had no jurisdiction to order the detention of the child to the woman's prison, and that the magistrate acted without malice and what he thought was in the best interest of the child. Long story short, the Court of Appeal found that the magistrate was personally liable once he acted without jurisdiction, even in a situation where he acted without malice of any kind. He was personally liable once he acted without jurisdiction or in excess of his jurisdiction. Now, the Court of Appeal is a court of law, and the court is going to call out the law as it sees it. It doesn't make the law. The court has expressed concern for the position of magistrates and has suggested that the time is right for the legislature to reconsider the liability of magistrates. So, Jason and Jagru and Mason has exposed and highlighted a serious vulnerability, one which will dampen and fetter the resolve of our magistrates in being able to act fearlessly and impartially, and generally to do what is necessary in the interest of justice and our people. I agree with the sentiments of the court that a magistrate, this is the Court of Appeal, they're saying a magistrate should not be personally liable for an innocent error of law or fact. I agree, our magistrates deserve better. And I want to suggest it makes little or no sense shoring up our crime detection, shoring up our enforcement capabilities, and then having cases break down at the level of the court because the magistrate feels enfeebled or is intimidated. It'll make a joke of everything. Now, what does indemnity mean? Indemnity means holding harmless against claims and liabilities. And there are indemnity provisions in many other statutes and bits of legislation. Just to quote a few. Section 13 of the Securities Industry Act. No action or other proceeding for damages shall be instituted against a commissioner or an employee or agent of the commission for an act done in good faith in the performance of a duty or in the exercise of a power under this act. Section 2 of the Public Authorities Protection Act. No action shall be brought against any person for any act done in pursuance or execution or the intended execution of any act or of any public duty or authority or in respect of any neglect or default in the execution of any such act, duty, or authority. Section 26 of the Data Protection Act. Proceedings shall not lie against the Commissioner or a person acting for or under the direction of the Commissioner for anything done, reported, or said in good faith in the exercise of performance or the intended exercise of performance of a duty, power, or function. So the magistrates are not being given any extraordinary bly. They're being not given any special treatment with this amendment. No one in public office, especially where such a person is acting in a judicial or quasi-judicial capacity, should face personal liability when acting in good faith or for an innocent error of law or fact. That's a basic principle. And I want to say, it's important to note that this legislation does not preclude appeals to the Court of Appeal, right? Nothing changes there. So the magistrate has made an error, or he called it wrong. The aggrieved person could still go to the Court of Appeal and have that decision revoked or changed and challenged. It's about personal liability of the magistrate. That's all that this is speaking to. And I also want to say, we were talking about whether this needs a majority because the rights of the citizens are being taken away. No, nobody's rights are being taken away. The aggrieved citizen still can maintain a claim for damages. He will maintain it against the state. We have a State Liabilities and Proceedings Act. The state will pay compensation due to any person who has been wrongfully dealt with or who is justifiably aggrieved. The state can be sued for the wrongful acts of its servants and agents. So this is not about supporting the AG or the government. This legislation has its source in a recommendation from the judiciary. It's not about politics. Now, it's about supporting and enabling the magistracy and the magistrate's profession so that they may better serve us. I have some thoughts and suggestions about the wording of the indemnity in the bill, which I will deal with at committee stage. But it needs to be appreciated also that the indemnity being offered is not absolute. It's qualified, right? An action can still be brought against a magistrate where he or she has acted maliciously and without reasonable and probable cause. So the legislation here is balanced, it's fair. But more than that, it is right and just. And I thank you, Madam President.
Senator Simonette.
Thank you, Madam President, for permitting me to join in this debate on an act, a bill to amend the Magistrates Protection Act. Madam President, I wish to endorse and support the Honorable Attorney General's approach. What the bill, in effect, is seeking to do is to address a distinction between the immunity enjoyed by judges of what we call superior courts and judges of inferior courts. Judges of our High Court enjoy absolute immunity from civil suit in respect of the work they do in the court, whereas those magistrates who are considered to be conducting their judicial work in the inferior court do not enjoy such immunity. Madam President, the bill seeks to amend the Act
by permitting or limiting the scope of actions permitted to be brought against a magistrate who is acting within jurisdiction, and accordingly, prior to this, who would have been exposed to liability personally. Given the proliferation of cases handled in the magistracy, Madam President, and given the changes being brought about in the administration of criminal justice in particular, it is in the public interest that magistrates feel empowered to dispense justice fearlessly and without favor. Accordingly, providing a similar immunity to that enjoyed by the judges of the High Court is desirable in the overall public interest and administration of justice. The distinction also is a distinction of anachronism coming out of our colonial past. Whereas in the days of feudal transacting, magistrates may not have been trained. In the modern society that we live in, magistrates certainly are well trained and in any event required to be lawyers of some 5 years qualification, so that errors that in the past may have been made by persons without training are less likely to be made today than in earlier times, out of which grew the distinction between superior and inferior courts. In relation to the question of the jurisdiction of the magistrate, that too is well defined by the various laws our magistrates are asked to dispense. Accordingly, the magistrate who acts innocently in a judicial capacity and makes an error ought not, Madam President, to be exposed to personal liability, as is the case now. My learned friend, Mr. Mark, Senator Mark, considers that there is a right that is being abrogated by the amendments being proposed by the Honorable Attorney General. And I could not disagree more with that position. Any aggrieved person has an ordinary right of appeal if a magistrate gets the issue wrong, and that appeal lies to the Court of Appeal. In relation to the question of the magistrate who acts outside the remit of his jurisdiction or her jurisdiction, the aggrieved person who considers that that has also been affected or actuated by malice
or without reasonable or probable cause, still enjoys his cause of action, albeit they must now bear the burden of proving that malice or that there was an absence of probable cause or reasonable cause. So that the proposition that a fundamental right has been abrogated and removed, contrary to the protections afforded in the Constitution, Madam President, is with respect a misplaced argument. The immunity that the magistrate would enjoy is an immunity that will now permit magistrates to proceed to dispense the work that they must do across a broad section of law without favor and without fear of conducting their work. And Madam President, this has been recognized in the cases cited by the Attorney General, and in particular in the House of Lords case of McSee versus Mullen, in the judgment of Lord Templeman. It's important to note what the distinction required to dispense the immunity requires. A magistrate may be acting fully within his jurisdiction, but he gets the law incorrect. And once he has been acting judicially in that capacity, he ought not, or she ought not, to be exposed to personal liability. Similarly, a magistrate may be conducting a case in which he is not permitted, or he has fell into error in convicting someone, applying a sentence that he had no jurisdiction to apply, but he did so innocently in error. Again, he should not be, or she should not be, exposed to any personal liability. It would be entirely different if such a magistrate were to look upon an accused and say, well, Senator Mark is wearing a Nero suit that I don't like, and accordingly impose an arbitrary sentence on him because of some malice. Then Senator Mark, of course, would have his cause of action once he can prove such malice. And no fundamental right of Senator Mark has therefore been abrogated. It is important, I think, Madam President, that the amendment be carried, simply given the volume and weight of the work conducted and undertaken by our magistracy. The freeing up of the criminal justice system, permitting for the magistrates to engage and transact further and more cases and caseload, means that there is a greater exposure to likely actions that are launched where magistrates, though acting wholly within their judicial capacity and jurisdiction, get an item of law wrong or an aspect of the law incorrect. So that I support the
amendments being moved by the Attorney General. I cannot agree with my learned friend, Senator Mark, on the question of the abrogation of rights. Rights of the citizen are sufficiently protected and enshrined in the appellate procedures and within the preservation of the right or cause of action should a magistrate be actuated by malice, or should he or she embark upon conduct or sentence without reasonable or probable cause. Madam President, I can see no reason to not approve the amendment being moved by the Attorney General, and with those words, I close in support of this bill.
Senator Chote.
Thank you, Madam President. May I say at the start of my very brief presentation that I support the proposed amendment, and I will very briefly set out my reasons for doing so. I speak because the reasons that I rely on have not yet been mentioned, but I think they might be of interest or they may be of relevance in the consideration of the consideration of this amendment. Now, there is a group called the Commonwealth Association of Magistrates and Judges, and they meet regularly, and the whole purpose of it is to ensure that the judiciary is respected and that member countries treat their judiciary in accordance with the Universal Declaration of Human Rights and their citizenry in accordance with the Universal Declaration of Human Rights. This has special significance for us because the anniversary of that declaration was quite recent. Now, there was an important report in 2009 which spoke about the status of magistrates in the Commonwealth and the apparent disparity of treatment between magistrates and judges, regardless of how the magistrates are called. Now, this is not something that is unique to our jurisdiction, even though there's a case, a recent decision from the Court of Appeal, which speaks about the apparent disparity in legal treatment of magistrates. The fact is, it is wrong, because we have signed on as a country, or we have agreed as a country, with what is referred to as the Latimer principles, and that is to say that we must ensure that our judiciary, and this includes our magistracy, we must ensure that their independence is adequately safeguarded. And that is crucial whether you are talking from the Chief Justice, the Justices of Appeal, the High Court judges, the Magistrates Court, the district judges, as some of them are now going to be called, the independence of the judiciary, and I'm talking about the offices. The independence of the judiciary must be adequately safeguarded. And it falls on our shoulders as members of the legislature to ensure that there is that level of deep protection for the independence of the judiciary. Now, a task force was set up to consider what was going on with these countries which had signed on, and Trinidad and Tobago is one of those countries, to look at how the association could deal with the apparent elimination of breaches of the Latimer principles. That is to say, where there was perpetuation of the distinction between the two arms of the judiciary. And in 2011, which was not so long ago, the member association to which I referred when I began my presentation called upon all law ministers, so that would mean your attorneys general, to consider taking appropriate steps to strengthen domestic legal framework and other measures assessing the independence and integrity of the magistracy. So I see that this proposed amendment being brought by the Honorable Attorney General is a step, a logical step, in accordance with what began a considerable time ago, of the consideration of the impact that this disparity in treatment has on a system of justice. I must say that I don't quite get the point about there being any constitutional issue. Could be that I missed the point. It could be that I don't know enough about constitutional law. But to me, if it is that that would be a concern, then we would see the citizen losing something. Right. Now, the citizen, in my respectful view, if a magistrate oversteps, and judicial officers, whether they are judges or magistrates, sometimes overstep. They are human beings. But if it is that we were taking away some sort of recourse that the citizen had from the citizen, then I think perhaps that then a constitutional issue may have arisen. But we are not doing so. Somebody who is wronged, let us say, by a magistrate who is overstepped or acted ultra vires or acted improperly still has the recourse that he or she had before. First of all, if the person is convicted, the person can go to the Court of Appeal, as with every other person who is convicted. If the person is not convicted, but there is some other wrong done, such as false imprisonment, as occurred in that case to which Senator Vieira has referred in some detail, then the person sues the state. So the remedies remain. So with these few words, I say that I see this advancement as a logical step in our progression of protection for the independence of the judiciary, which is an important institution in any democratic nation. And I support the amendment. Thank you, Madam President.
Thank you very much, Madam President, for allowing me the opportunity to join in this debate, which is a bill to amend the Magistrates Protection Act, very old Act of 1917. And Madam President, a lot have been said. I've prepared a very long speech, but while I was sitting here going along with this debate, I had to keep cutting down my notes because a lot have been said already in the debate. So, Madam President, I would just like to start off with a quote. And that quote is from the case of Sirius and Moore, 1979, Queen's Bench 118, at page 136, where Lord Denning, Master of Rules, said that, and I quote, Madam President, "Each should be protected from liability to damages when he's acting judicially. Each should be able to do his work in complete independence and free from fear. He should not have to turn the pages of his books with trembling fingers, asking himself, if I do this, shall I be liable in damages?" And when I read the bill, Madam President, the two substantive clauses of the bill, which are clauses 3 and 4, it attempted, Madam President, to remove this fear of a magistrate in terms of adjudicating upon matters, so that it removes a level of judicial pressure being placed upon a magistrate, because in any democracy, what is required is a free, fair, and independent judiciary without any pressures or external factors operating on the mind of a magistrate, because what that can do is cloud the judgment of the judicial officer. And when you look at the oath that the magistrate took, the oath says that he must, when executing his duties, do so conscientiously, impartially. Those are the two important words. And that he will discharge the functions of his office without fear or favor, affection, or ill will. And this bill, Madam President, is an attempt to do so. But when you look and you read the bill itself, it does not afford the magistrate complete indemnity or complete immunity or absolute immunity from any suit. Because the first substantive clause of the bill deals with, firstly, Section 4 of the Act. And it says that no action shall be brought against a magistrate for any act done by him in the execution of his office in relation to a matter within his jurisdiction. So that's the amendment. So the existing law would have allowed a person to bring a claim or a suit against a magistrate on two grounds. And this is my understanding on the reading of the original act. The first ground is that a person must prove that the magistrate acted maliciously and without reasonable and probable cause. So so the magistrate acted malicious, he acted without reasonable cause, probable cause, I can bring an action there. Then the second ground, which Section 4 speaks of, is that the magistrate must have done something not within his jurisdiction. And from my interpretation of Section 4, it seems as though there are two brackets: a magistrate acting within his jurisdiction, a magistrate acting without. So if a magistrate acts without a jurisdiction, when you read it together with Section 5, you do not have to prove that he acted maliciously or without probable cause. But when you look at when a magistrate acts within his jurisdiction, you have to also prove that the magistrate would have acted maliciously and without reasonable and probable cause. That is my reading. Now, when I looked at another jurisdiction, and that jurisdiction is Antigua and Barbuda, my interpretation of Section 4 and 5 of the original act was in line with what was stated in their legislation. So I thought that I may be correct in my interpretation of the law. So, Madam President, when you look at the amendment now, so let's measure what existed. So two grounds, malicious and reasonable probable cause within the jurisdiction, or the magistrate acting without, or he does not have jurisdiction. So those are the two grounds. When you look at the amendment now, what does the amendment do? The amendment removes any suit against the magistrate acting within his jurisdiction. So if, when this bill is passed, all a person can bring a claim now for is a magistrate acting where he does not have jurisdiction, or a magistrate acting in excess of his jurisdiction. So there is no question about whether or not he acted within his jurisdiction. But we must look at whether or not we have created an unintended injustice. Because there's a case, Madam President, R. Risi, a minor, 1984, 3 WLR 1227. And that case gave some examples of certain applications of the immunity provisions, which is found in the English equivalent. And it says, Madam President, what you will be protecting a magistrate now is that there's a balancing exercise. I know many senators spoke of protecting magistrates, but we must also look at the users of the court. So in one instance, they were saying that, okay, you're removing all of the, any ground to sue a magistrate acting within his jurisdiction. But what if a magistrate behaves unlawfully? What if he behaves maliciously? What if he breaches your right to a fair trial or natural justice, but acting within his jurisdiction? Madam President, it shows that they may have created an unintended injustice, and that was the example given in that case of Risi, a minor. And those are things that we must do at this stage of the bill in terms of examining the policies with respect to what the government intends to do and what it can actually do. And those are just some flags I wish to raise in terms of Section 4 of the Act, and that is Clause 3 of the bill. Now, when we look here now at matters where the magistrate acts outside of his jurisdiction. So the magistrate acts outside of his jurisdiction, existing law that is all you have to prove. The magistrate acted outside of his jurisdiction. This happened in the case of Jagru and Mason. Now, when we look at the amendment, you have to go one step further. You have to prove, one, that the magistrate had no jurisdiction or he acted in excess of his jurisdiction, but he did so maliciously and without reasonable and probable cause. Now, it's very difficult, Madam President, to prove malice on the part of especially a judicial officer. I mean, there may be examples, I'm probably too young to know, but there may have been examples in which judicial officers may have acted maliciously. But I think, in my humble view, that it will be a very heavy or very lengthy threshold in order for a person to cross to bring a claim personally against a magistrate. Now, this will be achieving the policy decision of the government that it makes it very difficult for someone to sue a magistrate personally. Now, when I was in law school, Madam President, and I was doing the course Civil Practice and Procedure 1, probably the first class we had, the lecturer would have told us that when you're suing someone and you're naming defendants, you always sue the person with the deeper pockets. So one example is that in an insurance matter, you don't just sue the driver, but you sue the insurance company for indemnity. And you always go after the person with the deeper pockets. And there are probably many examples in the jurisdiction where persons may not go after the magistrate personally, but go after the state in order to seek redress and damages for whatever wrong that they may have suffered. So that is in terms of the analysis that I have with respect to Section 4(5) of the Magistrate Protection Act. Now, I want to look also, Madam President, the Attorney General made a fleeting comment on this, which is with respect to the applicability of the immunity. We are absolutely certain that the immunity applies to a magistrate. But when you read Section 2 of the Act, it also applies to a justice. When you look at the Interpretation Act, a justice is interpreted as a justice of the peace. I take the Attorney General point that it's not all justice of the peace, but that would be the clerk of the court and the clerk of the peace, who at certain times may sit in a magistrate court to adjourn matters, to fix and grant bail. And this power is taken from Section 6(3) of the Summary Courts Act. But importantly, Madam President, right in the Senate, we recently passed a very important piece of legislation called the Criminal Division and District Criminal and Traffic Courts Act of 2018. And two offices were set up in that act: the Senior Magistracy Registrar and Clerk of the Court, which is formerly the Clerk of the Court, and the Magistracy Registrar and Clerk of the Court, who is formerly the Clerk of the Peace. And I looked at the proclamation, whether or not this act was proclaimed. And as at the 1st of December 2018, these positions exist in Trinidad and Tobago as they were proclaimed by Legal Notice 156, dated the 19th of November 2018. So right now we have these positions: Senior Magistracy Registrar and Clerk of the Court. Yes.
Thank you for giving me. Just quickly, those two positions were not proclaimed. They come into effect on the 1st of February. The rest of it was. It's in the second part of the proclamation notice.
Yeah, okay, Attorney General. I read the proclamation to say that the 1st day of December is the date on which the provisions of the Act, other than 325, shall come into operation. So everything else is in operation. So the entire Criminal Division Bill Act, is in force, and just those two provisions are not. Yes, well, I take your point. But you will know, Madam President, that these two positions, this bill that we're going to pass in this Senate, will affect these two positions because they can sit in the magistracy, again, as I mentioned, to adjourn matters, grant and fix bail. But I would just want to consider, Attorney General, should we extend the immunity to these persons? Simply because I read a lot of material on these things, and it says that these persons are not legally trained. First, they may have a lot of institutional knowledge, but are we going to allow persons who are not legally qualified the same immunity as a judge of the High Court, a Court of Appeal judge, of the Court of Appeal and a magistrate of the magistracy. And that is one point I would just ask you to consider in your wind-up. Again, there are other cases in the jurisdiction that speak of the indemnity, the Ramsey Hines and David Russell case, and the Crevel case that Senator Mark spoke of. But these cases, Madam President, the point I'm going to make is that a very short and simple point, are that these two cases there was no judicial determination per se upon Section 4 and 5 that we are trying to amend. It was actually an immunity granted by Section 6 of the Magistrate Protection Court Act, where if a magistrate issues a warrant for a person but an order or a conviction has not yet been made, the magistrate is protected under the Magistrate Protection Act. And those two cases would not be so helpful in terms of how we move forward with this bill. But the Indar Jagru case is a case on point with respect to what we are dealing with. And Madam President, I saw two amendments being circulated, and I promised that I would not be long, and hopefully in committee stage that we can continue the bipartisan approach, that we have offered amendments. It's very noble amendments I saw, and we hope that the government can seriously take into consideration what we have proposed, because at the end of the day, we have to protect our judiciary, because if our executive and our legislature is not doing the work, we must have the population must have confidence in an independent, impartial judiciary for our democracy to flourish. And I thank you very much, Madam President.
Honourable Senators, at this stage, we will suspend and we will return at 5 p.m. So the sitting is suspended until 5 p.m.